I was like, oh yeah, Maurice is on a mediation, and Kyle got that one too.
Wow.
And I didn't even realize that that was the case.
Well, so
All right, make sure this
Judge, I
is,
think that I know we're not really on the record yet, but on 18 CR 17, I know there's already been a stipulation or a finding that he violated.
right. Yeah, that was part of, I pulled up the plea agreement, and that was part of the plea agreement that
Right.
he was stipping to the violations.
Right.
Okay, all right, let's go ahead and be on the record in two cases, those being 2018 CR 17 and 2020 CR 24, both captioned State of Kansas versus Nathan Johnson. Would the parties announce their appearances, please?
May it please the court, State of Kansas appears by Assistant District Attorney Kyle Custer, appearing via Zoom.
May it please the court, Your Honor, Kind Caprice appears via Zoom with her client also via Zoom, but in a separate location.
All right, we are here set down for a sentencing today. Back on October 8th, the parties appeared also by Zoom. On that day, the defendant changed his plea from one of not guilty to no contest to counts 1 and 2. Per the plea agreement, count 3 was dismissed. The court inquired and accepted that. Ordered a pre-sentence investigation be prepared and set it for sentencing today. I've received that PSI. The critical findings are as follows. The primary offense of conviction is one of possession of methamphetamine, which is a severity level 5 non-person felony. The defendant's criminal history score was found to be that of E, as in Edward. That would leave him with a presumed sentence of 18, 20, or 22 months in the Department of Corrections, with a presumption of probation. However, by operation of special rule number 9, in which he was committed this crime while on probation, that leaves him without a presumption of prison or probation. If he has to do his time, he'll be eligible for 20% good time credit, subject to 12 months of post-release supervision. If he's granted probation today, it would be for a period of 12 months to community corrections. Count 2 is one of theft, a severity level 9 non-person felony. For scoring purposes, the defendant's criminal history score is I. That would leave him with a presumed sentence of 5, 6, or 7 months, still without a presumption for probation or prison, 20% good time credit, 12 months of post-release, and 12 months of probation if granted. The final count listed here is possession of drug paraphernalia. That was actually dismissed at the plea hearing. So the PSI will be amended to reflect that. With that change, Mr. Custer, did you have an opportunity to review the PSI? Do you have any additions, corrections, or challenges?
Apart from count 3 still being on there, I didn't have any other corrections to make to it, Your Honor.
Ms. Capri, same question.
Judge, no corrections other than the count 3 being on there. I guess I should note for the record too, that prior to going on the record, I did do a breakout room with my client and discussed his criminal history with him. So we are in agreement with the scoring of the crimes of conviction in this case and his history.
All right, Mr. Johnson, that's correct. Your attorney went over that criminal history worksheet and you agree that it's accurate?
Yes, sir.
All right. So part of the plea agreement was a request for a 6-month downward durational departure. Prior to coming on the record, I didn't see one filed, Ms. Caprice, but do you want to do it orally today and then file a written one immediately after the hearing?
Right, Judge. I had actually prepared one and for whatever reason it didn't get filed. I have filed it this morning, so
Okay.
it should
Good
be in the queue to be accepted by the clerks. I will
right.
tell you that it simply says 2 things. First, that in regards to dispositional departure, understanding that he's no presumption and we are requesting probation in this case, that the basis for my client's criminal activity has been drug use. He's been struggling with that for some time. And he has participated in a RADAC evaluation. I confirmed that this morning, although they are trying to get me the report at this time. They did that via Zoom due to COVID, and it took some time to get it done, but he did cooperate with that. Judge, regarding the durational departure, I would just ask that you follow the terms of the plea agreement that where both parties are asking for that. Judge, my client understands that he's going to be revoked and sentenced consecutively in this case to 18 CR 17, meaning he's going to be revoked in the 18 case, and whatever sentence you give him in this case is going to be consecutive. Judge, I'd also ask that both counts that he's going to be sentenced in this 2020 CR 24 case run concurrently pursuant to the plea. Judge, I would say to you, you know, my client's already been in custody since January 6th. He's been in custody for, 11 months at this time. And I think when all the math is done, he's not going to have much time to serve if the court, especially if the court agrees with the 6 months off. I think the best thing for not only him as an individual, but for society as well, is drug treatment that is going to hopefully turn this person around. Judge, he's not necessarily young, as it were. We happen to share the same birthday. Oh boy. But I think that his time in custody, which has been significant due to COVID and everything else, has taught him and given him a good taste of what being in custody is going to be. He'd rather do probation, which, as the court knows, is going to give him more services and be more supervisory than it would be just throwing his body into prison. So, Judge, that's what we're asking for today. We're asking that the court give him an opportunity. We understand the sentences will have to be consecutive between the two cases. We're asking for concurrent between the counts in this case and for that 6-month departure.
All right. Mr. Custer, your comments on defense request for departure and anything else touching upon sentencing?
Thank you, Your Honor. Just going off of what I have here from Mr. Brewer, I would agree that the 6-month durational departure was agreed upon at the time of plea. So I would not object to that, just going along with the plea agreement. And I have here from Mr. Brewer's notes as well that was a 6-month durational departure from the mitigated term in the appropriate grid box, just so that's perfectly clear. As far as the dispositional departure, that's not contemplated in here. I had assumed the reason why they had a durational departure was contemplated was because the idea had been there would be a sentence imposed. So it would appear that the intent of the agreement that Mr. Brewer made, as far as I can tell, is that the state would recommend the court not dispositionally depart, that the 2 counts in the 2020 CR case run concurrent to each other, and then that the sentence in the 18 CR 17 case be imposed consecutively to the 2020 case.
Right. The plea agreement, as it was done on the record, I think all parties realized that the defendant was going to be presumptive probation, but for the fact that he was on probation when this was committed. But instead of making him presumptive prison on that, it just destroys a presumption. So there is no presumption one way or another. And the parties agreed that each side would retain their rights to argue for probation and against probation.
Okay. And I'm just going off of what I can tell from, I don't know everything that Maurice and Ms. Caprice would have talked about this. Usually when I see that somebody has contemplated a durational departure, that usually indicates that they've assumed or agreed that a prison sentence is going to end up being imposed. Yeah. So that's what I'm going off of.
Okay.
Judge, if I can jump in there, I hope nothing that I said implied that I had an agreement with Mr. Brewer that he would agree to probation. That's certainly not the case. Right. The agreement was that we could each argue our positions. And just so Mr. Custer understands, I'm not indicating at all or inferring at all that Mr. Brewer agreed to my request for probation.
Right. No, I think that was clear. And that unfortunately, the problem with this is kind of change in prosecutors between the plea and the sentencing. So Mr. Custer wasn't able to be there for that, and he's just kind of going off some notes. But I'm very clear in my head what we have here was the agreement was that they would agree to a departure and that both sides would have the opportunity to argue disposition without any agreement between the parties as to what to recommend to the court. So I think we're all good on that. Mr. Johnson, you're not required to, but now is your opportunity to tell me anything you want me to know in mitigation of your sentence today.
No, I'm good with what you guys are talking about.
All right. Ms. Caprice, do you know any legal reason why I should not now proceed to sentencing?
No, Your Honor, thank you.
All right. I'm going to follow the plea agreement. I will grant the downward durational departure requested by the defendant as part of this plea agreement without objection from the state. I find substantial and compelling reasons as argued by the defendant. Also, that he accepted responsibility, saved the state the time and expense of trying this case. I believe that given, I think Ms. Caprice is absolutely accurate that the basis of the defendant's criminal activity is his drug substance abuse issues, and that a non-prison sanction would serve defendant reformation, public safety better than a prison sentence. So I guess what I'm saying is I'm granting the downward durational departure for 6 months off the 18 months that is mitigated, which would leave a sentence of 12 months in the Department of Correction. Although there is no presumption as to probation or not, for the reasons that I gave just a moment ago, I find that a sentence granting probation is more effective, more rational, and more fair than a prison sentence in this case. So I will grant the defendant's motion for probation for a period of 12 months to community corrections. If Mr. Johnson ever has to do his time, he'll be eligible for 20% good time credit and subject to 12 months of post-release supervision. As to count 2, he will be sentenced to the standard term of 6 months, and it will be ordered to run concurrently with count 1 in this matter. Both of these sentences are ordered to run consecutively to the case 2018 CR 17. That's by operation of law and the decision of this court. And so before I get to costs and fees and all of that, I think we should take up this matter. The defendant has already stipulated to violation of his sentence in the 2018 CR 17 case. I see that he was sentenced to 7 months in prison in that case. Mr. Custer, Ms. Caprice, do you know exactly how much time the defendant has spent incarcerated on these cases?
He's been in jail this time since January 6th of 2020. The PSI is correct on that, right, Nathan?
Yes, ma'am.
So however many
right.
days that is.
All right. Well, look, it sounds like what's going to happen is he will get credit for his entire sentence in 2018-17, and then whatever is left over after that will be credited to this sentence as far as jail time credit goes. So, Mr. Johnson, it looks like you're going to be getting out of here very quickly. Can you tell me what is your plan for making ends meet? Do you have a line on employment?
Yes, I'm gonna try to go back to doing tree work. Like I've been locked up 11 months, so I don't know if the guy I was
Right.
working for will still allow me to work for him. But I mean,
What's your living arrangement going to be?
I'll be living with my girlfriend.
Okay. All right. Mr. Custer, do you happen to have a restitution number in this case? I think there was the victim. I don't know if she had requested any, but we had a name for a possible request, Robin Carlton.
I hadn't seen one, Your Honor. Let me look through that really quickly just to see if there's something in here that I had not.
Oh, and Judge, while he's looking, I'll note for the record, it looks like ECF has now received that sentencing motion. So it should be
All
accepted
right.
here before too long, and it should be in your thing.
In my
Your
queue.
Honor, according to the original journal entry of judgment from the 2018 CR case, he was not ordered to pay any restitution on the 18
Right.
CR case.
Yeah, I was more concerned about the new case. However, I do see that the vehicle was recovered, and I don't know that, I don't see that there's any more, at least in the affidavit, report of damage to the vehicle. So I'm going to assume if the state's not got anything at this time that.
Yeah,
no-
I don't believe there's any request for restitution in the new case either.
All right. So it looks like, Mr. Johnson, you're going to be able to get some work here somewhere, and you've got a living arrangement that will work with you. So I think, and Ms. Caprice, are you appointed or retained?
Judge, I'm appointed, but I'm going to ask that the court waive attorney's fees, just because, first of all, they're not going to be that extensive. It's not going to be an exceptional or anything of that nature because he did enter into a plea. And second of all, because he is going to probably have to pay for some sort of drug treatment, get back on his feet. He's been in custody for 11 months. That may take some time to find a job and what have you.
Okay. And it looks like, I'm trying to see if he has prior felony in Kansas, and I'm not seeing it. It looks like all of his felonies were Missouri, which, leads me to want to waive that because he's going to end up having to pay the DNA database fee. So here's what I'm going to do. I'm going to order, as far as costs go, the court costs and supervision fee. I'm going to waive his attorney fee, including the bids application. I have to order the database fee, so that will be required. There's not going to be any other fine. I know the drugs were not tested, so there's no lab fee. That should be enough. And with that, if he can pay $75 a month, that's about as low as I can get it, and still get him paid off before his probation ends. Mr. Johnson, do you think that if I ordered $75 a month, that could be something that you would be able to make?
Yes, sir.
That will be the order as far as the costs and fees go. All right, on 1817, I'll find the defendant has stipulated the violation. I will revoke his probation, order him to serve his sentence. He will be credited for all the time he's been in until that flattens out that sentence, and the remainder of the jail time credit will be applied to the 2020 case. Mr. Johnson, you have 14 days from today to appeal anything you don't like about your sentence. You may also be able to seek expungement after a period of time following successful completion of probation. As a convicted felon, it's prohibited for you to own or possess a firearm, certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered deadly weapons. I won't go through the whole list, but suffice it to say, before you decide to arm yourself, own or possess any kind of weapon like that, make sure you talk to a good lawyer like Ms. Caprice to make sure that it wouldn't be a reason to revoke a probation or add new charges. Okay?
Yes, sir.
All right. So I'm going to be signing a release in both cases today. Do you, I need to give you a phone number to call your probation, get it set up once you get
Yeah.
out.
Pen and paper, so you give me a phone number, please.
By the way, unless there's something the lawyers know I haven't put on the record, we will just adjourn from the record before I give them this. And
Well, Judge, one thing I want to say on the record, Mr. Custer, we haven't worked together before. The only thing I'm concerned about in this case is the proper allocation of jail credit. I'm not sure how journal entries are being done with, the uptick in COVID and all that business. Can you just make sure that I get it and my signature is not waived or whatever? I don't care if you email it to me or whatnot. I just want to make sure the jail credit's appropriate.
Sure,
And
absolutely.
with that, thank you so much. And Nathan, with that, I'm going to need you to call me when you get out. So when Mr.
Hold on,
Custer gets, go ahead.
hold on one second. We are adjourned for, oh, wait, I'm sorry. Ms. Herron, did you need something else on the record? Okay, we are off the record. Thank you, Ms. Taylor. We'll see you here in about 15 minutes. All right, and then I'm going to stop the live stream so I'm not giving the public the phone numbers here.
Okay.
Um,
And